Mr. Stangler, why was DHEC unable to force Carolina Water Service to comply with the Clean Water Act, as you state on page 8 in your rebuttal rehearing testimony?
I can't speak to the exact reasons that they weren't able to do it. They certainly made some attempts, and to be completely honest, it seems like they just gave up. After years of litigation, the case that they had was stayed and was never picked back up, and they stopped issuing enforcement actions.
Thank you. All I have, Mr. Chairman.
Commissioners, anyone else? Mr. Nelson, redirect. Okay. Mr. Stangler, you may step down and you are excused.
Thank you very much.
Okay, let's move ahead. Call your next witness.
Mr. Chairman, we'll start with Mr. Sullivan, please, if it please the Commission. Mr. Sullivan, would you please state your full name and occupation?
Name's Daniel Sullivan. I'm employed by the Office of Regulatory Staff as the Deputy Director of the Audit Department.
And did you pre-file 6 pages of direct rehearing testimony in this case on August 16th?
Yes, I did.
Do you have any changes or corrections to that pre-filed rehearing direct testimony?
Yes, I do.
What corrections, please?
This is my direct rehearing testimony, page 4, line 18. Delete the word both. And the last word on that same line, line 18, and. So delete both on line 18 and the last word, and. Also, page 4, the next line, line 19, delete Watergate. And also on line 19, change the word facilities to facility. Those are all my corrections. I can reread the whole sentence.
Could you read the sentence as corrected, please?
Yes. ORS was aware that CWS was under South Carolina Department of Health and Environmental Control consent orders for the Fryersgate Wastewater Treatment Facility during the test year.
With that correction, is your direct testimony correct now?
Yes.
Mr. Chairman, I would ask that Mr. Sullivan's direct rehearing testimony as corrected be entered into the record as if given orally from the stand.
Okay, Mr. Sullivan's direct testimony as corrected will be read into the record as given orally from the stand. Thank you.
And with your direct testimony, did you prepare and pre-file 2 exhibits marked Rehearing Audit Exhibit DFS1 and DFS2?
Yes, I did.
And do you have any changes or corrections to those exhibits?
No, I do not.
Mr. Chairman, I would ask that the exhibits attached to Mr. Sullivan's direct rehearing testimony be marked as the next hearing exhibit and entered into the record.
Mr. Sullivan's exhibits DFS 1 and 2 will be entered as Exhibit 14.
Thank you, Mr. Chairman. And as parties have agreed, and if it meets with the Commission's approval, we'll enter rebuttal testimony at the same time. Thank you. Mr. Sullivan, did you also pre-file 4 pages of rebuttal rehearing testimony in this case on August 29th?
Yes, I did.
And do you have any changes or corrections to your pre-filed rebuttal rehearing testimony?
No, I do not.
If I asked you the questions in that testimony today, would your answers remain the same?
Yes, they would.
Mr. Chairman, I would ask that Mr. Sullivan's rebuttal rehearing testimony be entered into the record as if given orally from the stand.
Mr. Sullivan's rebuttal testimony will be read into the record as given orally from the stand.
And Mr. Sullivan, did you also prepare or cause to be prepared 3 exhibits consisting of 7 pages marked rebuttal rehearing audit exhibit DFS1 through DFS3?
Yes, I did.
And do you have any changes or corrections to your exhibits?
No, I do not.
Mr. Chairman, I ask that the 3 exhibits attached to Mr. Sullivan's rebuttal rehearing testimony be marked as the next hearing exhibit and entered into the record of this case.
Okay, Mr. Sullivan's exhibits attached to his rebuttal DFS 1 through 3 will be entered as exhibit number 15.
Thank you, Mr. Chairman. Mr. Sullivan, do you have a summary of your direct and rebuttal testimonies?
Yes, I do.
Would you provide that to the commission at this
Sure.
time?
Good afternoon. I'm not sure when evening starts, but I'll stick with afternoon. Mr. Chairman and members of the commission, the purpose of my direct and rebuttal rehearing testimony is to describe the process employed by the ORS Audit Department that led ORS to normalize sludge hauling expenses, support the use of normalization adjustments and other types of pro forma adjustments as part of the rate-making process, and show the results of ORS proposed rehearing adjustments using the Commission's approved return on equity. ORS's initial review of the company's application involved obtaining the trial balances for the test year and the previous 2 years. ORS then compared the balances in each account for the test year with the balances in that account for the previous 2 years. ORS then set threshold criteria for dollar increases and percentage increases to identify accounts which ORS would request the company to provide explanations for the increases. For this docket, ORS set $20,000 and 10% as the threshold criteria to identify accounts to request from the company explanations for the increases. ORS also judgmentally selected additional accounts that did not meet the threshold criteria to request explanations from the company for any increases. Account 6410, sludge hauling expense, increased $150,555, or 76% from 2016 to 2017, and therefore was identified as an account with an increase meeting the threshold criteria. ORS requested the company to provide an explanation for the increase in sludge hauling expense. The company's response was that sludge hauling expense had increased partially due to control of the Friarsgate wastewater treatment facility sludge inventory at the plant, and that sludge hauling expense was also being addressed through the company's inflow and infiltration, or I&I, capital project on the Friarsgate collection system. ORS further analyzed the sludge hauling expense account and identified the Friarsgate and Watergate business units as the primary business units responsible for the increase in sludge hauling expense. It was ORS's opinion that the test year sludge hauling expense amounts for these business units were atypical, did not indicate future conditions, and were abnormal. ORS was aware that the company was under South Carolina Department of Health and Environmental Control consent orders for the Friarsgate wastewater treatment facility during the test year. Work was also being performed on the equalization basin at the Friarsgate wastewater treatment facility, which involved removal of large amounts of sludge. Additionally, a capital project had been established aimed at correcting I&I issues for the Friarsgate collection system. The consent orders, work on the Friarsgate equalization basin, and the Friarsgate I&I project were considered non-recurring and contributors to the increase in sludge hauling expense for the test year. ORS recognized that absent the consent orders or work performed on the Friarsgate system, there would continue to be sludge hauling expenses at both the Friarsgate and Watergate wastewater treatment facilities, and therefore, ORS averaged the previous 3 years of sludge hauling expense to calculate the ORS proposed adjustment of $96,892. The purpose of this adjustment was to normalize the expense to more closely reflect sludge hauling expenses in a typical year and thus normalize the company's operating experience. I support the use of normalization adjustments by including an excerpt from Accounting for Public Utilities as my rebuttal rehearing audit exhibit DFS1 that specifically addresses the types of pro forma adjustments ORS implements and are appropriate to adjust test year data. Normalizing adjustments made to restate test year period data for abnormal conditions is one type of pro forma adjustment that is critical in determining the company's cost of service. I note that the company proposed multiple pro forma adjustments to adjust test year data to reflect the level of expenses expected to occur in the future. The company annualized salaries and wages, adjusted purchased water and sewer to reflect a going forward expense level, and adjusted for the removal of the I-20 sewer treatment plant since it would no longer be operated by the company. I also prepared surrebuttal rehearing audit exhibits DFS-2 and DFS-3 to incorporate the ORS proposed rehearing adjustments. Surrebuttal rehearing audit exhibits DFS-2 and DFS-3 update my direct rehearing exhibits for the changes made to the equalization basin adjustment as discussed by ORS witness Dawn Hipp as part of her surrebuttal testimony. Surrebuttal rehearing audit exhibit DFS-2 shows the result of ORS's updated proposed adjustments based on the PSC approved return on equity of 10.5% would be a net reduction to revenues for the company of $116,185. This concludes my summary.
Thank you, Mr. Sullivan. Ms. Hipp, would you state your name and occupation for the commission, please?
Certainly. My name is Dawn Hipp, and I'm the Chief Operating Officer with the Office of Regulatory Staff.
And did you pre-file 30 pages of direct rehearing testimony in this case on August 16th?
Yes, I did.
Do you have any changes or updates to your pre-file testimony?
There's one small update. My job title changed on August 17th, and that is not reflected in my direct testimony.
And that would be on page 1, line 13?
That's correct.
And that new job title is?
Chief Operating Officer.
Thank you. With that update, if I asked you the questions contained in your pre-file direct rehearing testimony, would your answers remain the same?
Yes, they would.
Mr. Chairman, I ask that the pre-file direct rehearing testimony of Ms. Hipp be entered into the record of this case as if given orally.
Ms. Hipp's pre-file direct rehearing testimony will be read into the record as given orally from the stand.
Ms. Hipp, did you also prepare 8 exhibits marked rehearing exhibit DMH1 through DMH8 and which were attached to your pre-file direct testimony?
Yes, I did.
And of those exhibits, are rehearing exhibits DMH2, 3, 4, and 5 filed under seal because those exhibits contained records deemed confidential by CWS?
Yes, they are.
Do you have any changes or corrections to either the public version or the confidential version of your exhibits?
No, I do not.
Mr. Chairman, I'm going to ask that there be 2 hearing exhibits, one for the public version of these exhibits and then the confidential version in a separate exhibit. So at this time, I would ask that the public version of Ms. Hipp's rehearing exhibits DFS-1 through DFS-8, which were filed with the Commission as attachments to the pre-filed direct rehearing testimony, be marked as the next hearing exhibit entered into the record of this case.
Okay, Ms. Hipp's testimony, public exhibits, DMH 1 through 8 will be entered as hearing exhibit number 16.
I also request that the confidential versions of Ms. Hipp's exhibits DMH2 through DMH5, which were filed under seal with the Commission, be marked as a composite exhibit and marked as the next hearing exhibit number and entered into the record of this case.
Okay, Ms. Hipp's confidential exhibits 2 through 5 will be entered as exhibit number 17.
Thank you, Mr. Chairman. Ms. Hipp, did you also prepare and pre-file 14 pages of surrebuttal rehearing testimony?
Yes, I did.
And do you have any changes or updates to your surrebuttal testimony?
No, I do not.
If you were asked those questions from the surrebuttal testimony, would your answers remain the same?
Yes, they would.
Mr. Chairman, I'd ask that Ms. Hipp's pre-filed surrebuttal rehearing testimony be entered into the record as if given orally from the stand. Surrebuttal.
Ms. Hipp's surrebuttal testimony will be read into the record as given orally from the stand. Thank you.
Thank you. And Ms. Hipp, did you also prepare 2 exhibits marked Surrebuttal Rehearing Exhibit DMH1 and DMH2, which were attached to your surrebuttal testimony?
Yes, I did.
And do you have any changes or corrections to those exhibits?
I do not.
Finally, Mr. Chairman, I ask that Ms. Hipp's 2 exhibits, DFS1 and DFS2, that were attached to the surrebuttal rehearing testimony be marked as the next hearing exhibit and entered into the record of this case.
Okay, Ms. Hipp's surrebuttal exhibits DMH1 and 2 will be entered as exhibit number 18.
Thank you, Mr. Chairman. And Ms. Hipp, do you have a summary of your direct and surrebuttal testimonies?
Yes, I do.
Please provide that to the Commission.
Certainly. I could be optimistic and say good afternoon like Daniel has done. However, I think we'll go good evening. Chairman and members of the Commission, thank you for the opportunity to discuss these issues, which we find are very important to CWS ratepayers. In summary, ORS requests that the Commission amend its ruling in Order 2018-345A to adopt ORS's adjustment to remove $96,892 in order to normalize sludge hauling and disposal expense, as you've heard from ORS witness Sullivan. Deny recovery of $336,915 in litigation expenses attributed to the U.S. District Court case with the Congaree Riverkeeper, in which CWS was found to have violated its environmental permits on numerous occasions. Deny recovery of $130,643 in litigation expense attributed to the U.S. District Court case CWS initiated against the U.S. EPA and Town of Lexington that was subsequently dismissed. Establish a regulatory asset for litigation costs related to the Town of Lexington condemnation action and the 2 appeals of the DHEC administrative orders. And the Commission and ORS have agreed to a deferral account for those charges related to the Town of Lexington condemnation, and you heard about that earlier today. And then finally, adopt ORS's adjustment to remove approximately $2,242 in plant and service related to the EQ basin. I'd like to break down, even at this late hour, our detailed explanation as to why these adjustments are appropriate for the Commission to look at. First, sludge hauling. As explained in ORS's testimony, the test year expenses for sludge hauling at the Watergate and Fryersgate wastewater treatment facilities were atypical in comparison to the sludge hauling expenses reported by the company for the years 2015 and 2016. While the company provided no specific reasons for the higher than normal sludge hauling expense at their Watergate facility, the company acknowledged one of the causes of the higher than normal sludge hauling expenses at Fryersgate was due to a DHEC consent order requiring more diligent sludge management. Upon further review, ORS applied an adjustment to reduce sludge hauling expenses and normalize them, and the adjustment is approximately $96,892. And that adjustment was calculated by using the average of the sludge hauling expenses for 2015, 2016, and 2017. ORS incorporated the higher level of expenses experienced by the company during the test year into its calculation of the 3-year average. This type of adjustment, as witness Sullivan has spoken about, is commonly used by this Commission and other commissions to adjust test year data to accurately reflect typical conditions which may reasonably be expected to occur in the future period for which these rates are set. As CWS has indicated, the company recently implemented cost-saving measures and filed for an approval to interconnect its Fryersgate facility, which will reduce the monthly sludge hauling costs. ORS supports its original adjustment to reduce and normalize sludge hauling expenses because the adjustment provides a reasonable balance for rate-making purposes and adjusts the expenses to be more representative of future operating conditions than just a simple application of the test year expense levels as recommended by the company. Moving on to litigation expenses, which we find are an important part of this case. I think it might be helpful for me to provide just a basic overview of ORS's position on the litigation expenses. Today, CWS customers are paying rates for wastewater service that include approximately $1 million in litigation expenses. Of that $1 million, approximately $340,000 are attributed to the U.S. District Court case in which CWS was found to have violated the Clean Water Act and severely fined by the court. CWS has not demonstrated that its customers received any benefit from this litigation. In fact, the customers have not received the service quality that the Commission regulations require. Commission Regulations 103-540 require CWS to operate and maintain in safe, efficient, and proper conditions all of its facilities and equipment used in connection with the services it provides to any customer. Likewise, in Commission Regulation 103-570A, CWS is required to comply with all laws and regulations of the state and local agencies pertaining to sewerage service. CWS should not be rewarded for failing to provide service in compliance with state and federal laws. If CWS is allowed to recover these legal costs from their customers, the company has no incentive to operate its utility systems in compliance with state and federal laws. Customers are also paying for approximately $130,000 in litigation expense attributed to CWS's attempt to sue the U.S. EPA and Town of Lexington. This case was dismissed, as you had heard earlier today, and again, CWS has not demonstrated how the customer benefited from this attempt to sue the town and the U.S. EPA, in which was characterized by one of the witnesses today for CWS as very difficult to win. CWS's attempt to sue the U.S. EPA and the Town of Lexington was not successful, did not minimize costs, and CWS should not be allowed to recover these litigation expenses from the ratepayer. Turning to the condemnation and the two DHEC appeals. Condemnation of the I-20 sewer system by the Town of Lexington and the appeals of the DHEC administrative orders are ongoing, and no final order has been issued. Therefore, it is premature for CWS to be allowed to recover these costs from ratepayers. CWS's current rates include these litigation expenses, yet the cases aren't concluded and the outcomes aren't known. ORS recommends a regulatory asset be established for the legal expenses related to the condemnation and appeals of the DHEC administrative orders, such that the Commission can consider these expenses and how they should be treated in the next general rate case. The regulatory asset, as we had discussed earlier, should be limited only to the litigation expenses, and no carrying costs should be allowed to accrue. And as I mentioned, the company and ORS agree that the Town of Lexington expenses should be placed in a deferral. At a more granular level, because we want to get in deep this late in the afternoon, ORS analyzed and verified the legal expenses and invoices, the allocation of those expenses that were contained in the total that's in the Commission order of $996,808. In its rehearing testimony, CWS indicated that several of the invoices included for recovery in that original order were not attributed to the 5 legal actions that we're addressing today and are in dispute. CWS indicates that the proper starting balance for litigation expenses for the rehearing is $991,508.64. And ORS recommends the Commission adopt the following adjustments to that starting balance based on ORS's review of these legal invoices and the allocation. Remove $467,558.64 in expenses after ORS adjustments to address redactions, allocation errors, and unallocated and unsupported expenses and advances related to the 2 U.S. district court cases in which the customer received no benefit. Establish a regulatory asset for the legal expenses related to the condemnation of the I-20 sewer system and the 2 DHEC appeals. The current total for these actions are roughly $334,406. No expenses would be recovered from customers until the outcomes of the litigation are final and the Commission establishes an amortization period for the deferral in the next rate case. And finally, remove $189,543 in legal expenses related to work descriptions that contained a redaction which limited ORS's review of the work performed, or for expenses and advances that were unallocated, unsupported, and undocumented. Turning to the Friars Gate EQ Basin Liner Project. Order 2018-345A allowed CWS to include $1,081,375 as plant and service related to the Friars Gate EQ Basin Liner Project. As you recall, ORS did not agree with CWS's pro forma adjustment to plant and service related to this project because the EQ liner was not installed and it was not providing service to CWS customers. ORS's original proposal would have allowed CWS to add the capital project to plant and service once it was in service to the customers, which most likely would have been in the next general rate. CWS indicated through discovery and its testimony that the project scope for the Friars Gate EQ Basin Liner project has changed, and the company has separated the project into 3 phases. Phase 1 is for project expenses related to soil remediation. Phase 2, in general, is for project expenses related to the liner installation and the interconnection to the City of Columbia. And Phase 3 is for project expenses related to the Friars Gate collection system, infrastructure repairs, and replacement. Given the changes to the project scope as detailed by CWS, ORS agrees that $1,079,132.84 should remain in plant and service related to Phase 1 site remediation and Phase 3 collection system infrastructure repairs. Based on ORS's review of the invoices supplied by CWS for these projects, ORS recommends a very minor adjustment to remove $2,242.51, which is attributed to late fees that the company paid to a vendor and costs to reinstall grass matting. CWS did not challenge this minor adjustment. Finally, turning to the issue of rate design and revenue requirement allocation. ORS understood and implemented the rate design approved by the Commission in Order 2015-876, when ORS proposed its rates to allocate the revenue requirement in its proposed order. However, ORS's revenue allocation for water customers in Service Territory 1, which was based on CWS's cost of service, reflected an increase. In contrast, CWS proposed a reduction in rates for some of the water customers in Service Territory 1, which was adopted in the Commission order. No justification or reason was provided in the order for the reduction in rates, and ORS was concerned that other water customers in the service territories may be disadvantaged. Based on the direct and rebuttal rehearing testimony of CWS witness Bob Hunter, ORS now fully understands the company's method it used to allocate the increase in revenue requirement attributed to water customers in both Service Territory 1 and Service Territory 2. ORS recommends that any order from the Commission on rehearing include a sufficient amount of detail to support the revenue allocation and the resulting rates. This concludes the summary of my rehearing testimony.
Mr. Chairman, Mr. Sullivan and Ms. Hipp are available for cross-examination from the parties and questions from the commissioners.
Thank you. Thank you. Ms. Valtorta. Mr. Knowlton. CWS.
Anybody know the password? Erskine, you know the password?
Questions are shorter.
I think it will be.
We hadn't found that to be the case anywhere so far today.
Let me see if I can deliver. Actually, the longer this drags out. There you go.
Thank you, Mr. Erskine.
Mr. Sullivan, you were very helpful in attaching as your surrebuttal audit exhibit DFS1 an excerpt from Accounting for Public Utilities dealing with normalization. That's the Hain document. You know what I'm talking about there?
Yes, I'm actually.
Can you go ahead and flip to it?
Yeah, I have.
If you will look at the third page of that exhibit, which is page 7-7, and turn to the second full paragraph with me. And I'm just going to read it so we can follow along. It says, one consideration in identifying extraordinary and non-recurring events that justify normalizing adjustments is whether the event actually has an extraordinary and non-recurring impact on operations. Many events, if viewed in isolation, might be considered extraordinary or non-recurring, but if viewed from an overall operating perspective, might be part of a routine cost of doing business. For example, a car owner may have an unexpected and costly generator failure at one point in the car's lifetime. Battery failure may, however, occur at some other time, or starter failure may occur, and so on. Any of these failures may be a one-time non-recurring event, but a different one may occur each year. Any one of the specific problems may be non-recurring, but will be replaced by other problems, and the annual cost of operating the car may therefore be normal. It is in this context, that the normalizing adjustment should be considered. Do you agree with Mr. Hahn on this point?
I agree with his premise that some years costs are going to be higher in some areas and other years lower in other areas. I think the difference, though, in our adjustment in this is the use of extraordinary and non-recurring. I think of extraordinary and non-recurring as an expense like a hurricane expense, where it might happen once every 5 years. Our adjustment is not saying that the company will not experience sludge hauling expenses. We understand the company will incur sludge hauling expenses, but what we are saying is that they were atypical or abnormal during that year, and so we made our adjustment just to normalize them, to make them typical of a normal year.
Yeah, and I understand that, but it seems to me that the author is saying something different here. Because if you look at that last sentence, he says a battery failure may, however, occur at some time, or a starter failure may occur, and so on. So he's not saying we're going to have a battery failure one year and we may have another battery failure the next year. He's saying one expense.
Can we get to the question? He's testifying to his opinion of what this says. Can we have a question to the witness, please?
Mr. Chairman, I'm entitled to set forth the authority that Mr. Sullivan's relying on and ask him his opinion on it. He gave me a quite lengthy explanation of his position on this. I'm just looking at the authority he's citing.
Okay, I'm going to overrule that objection and you continue on.
Okay. So, Mr. Sullivan, my point in the question I'm trying to ask you is the author here is talking about different things can occur. So let's assume, for argument's sake, that the Friars Gate plant is the car and the sludge hauling is the battery. We had a battery expense, but it doesn't mean that the plant won't have an alternator expense, or in this case, a contract operation expense the following year, right?
I agree that different things can go wrong with a facility and different
are expected to. And not just wrong, different expenses will be incurred in different years, and we've heard testimony to that effect, right?
I'm just I want to point back to how he starts the paragraph, and it says extraordinary and non-recurring.
But let's finish that sentence for me, please. Non-recurring what?
Events.
No, sir.
And
Extraordinary non-recurring impact on operations, right?
Okay, yeah, I was on the first line. You were at the end of the sentence.
Okay. I'm just saying the point is the impact that has to be extraordinary, not the specific item that has to be extraordinary, because things are going to happen. Just like they happen to the car, they're going to happen to the plant. Would you agree?
I agree that things are going to happen to the plant.
Right.
But when those things happen to the plant, I believe as from a rate-making perspective, you should take those into consideration and normalize them. I mean, things are going to happen with salaries. They're going to go up. They're going to lose employees, et cetera.
But you don't always normalize. I mean, there's a judgment call there. Would you agree with that?
Yes, I agree that there's a judgment call.
Okay, and so
it's based on what we did here. It's based on the previous 3 years and the abnormal increase in the test year.
But you could also judge that other things are going to happen in this plant. There are going to be other expenses down the road. And just like a car's got to replace a battery and maybe an alternator the next year, in this case it could have been contract operations and so forth. It doesn't mean that the impact on the plant, which is what your author says you should look at, is extraordinary. The sludge hauling may be, but the impact may not be. Are the expenses for operating Friarsgate really expected to go down in the future?
We believe sludge hauling expenses will go down.
Sludge hauling, but not the overall expenses. You're not saying
I can't predict the overall expenses for Friarsgate in the future.
Thank you, Mr. Salt.
Okay, Mr. Elliott.
Ms. Hipp, let's talk a little bit about the ORS practice in the event of a rate case. And we'll focus on this rate case as an example, shall we? All right. So Carolina Water Service will file an application for a rate increase. And with its application, it files certain schedules as required by the Commission, correct?
Yes.
And once ORS has the rate application and the schedules and has had an opportunity to review them, it will then issue a data request, correct?
We do.
All right. And I think they're sort of voluminous. There are a couple of hundred of them that are standard by now. Is that correct?
We try to make it, 200 to 300. No, they're roughly 100, sometimes 150, and there will be subsequent requests based on those answers.
Right. So, so you serve that on Carolina Water Service and give them a reasonable amount of time to respond to them, correct?
We do.
And once you get those initial 150 responses, as you testified, you will serve, what do you call them? URRs, utility
Rates request.
Right, and also AIRs?
Yeah, audit requests.
All right, so you have follow-up discovery, correct?
We do.
And when you as you begin to audit and investigate a rate increase, it's important for you to look back to the previous rate increase to establish some baselines for the rates and the revenues and the expense requirements, correct?
Our audit department will look at historical data. In fact, they'll use the annual reports. They'll take the commission order from the last rate case, roll forward plant adjustments, the plant, and then take a look at what's happening in the annual reports of the utility.
And so in the course of all that, I think you would admit that Carolina Water attempts to be attentive and responsive to your data requests. Would you agree?
They are, yes.
And as I understand it, Carolina Water will actually provide the ORS with data during the course of years where there is no rate case, just to keep you up to speed. Is that correct?
We do some pre-work in anticipation with cooperation of the company.
And so by the time we arrive, generally speaking, at the pre-filing stage, or at least when the ORS arrives at the pre-filing stage, it has obtained the information it has requested from the company and preparing it for its pre-file testimony, correct?
Yes.
And even after the filing of pre-file testimony, the ORS is very good about accepting additional known and measurable information from the company where appropriate.
We will continue to fine-tune our adjustments during the testimony.
Now, we are here on a rehearing matter, and as a part of the rehearing, the ORS served additional discovery or data requests on the company. Is that correct?
We did.
And the company has responded to those data requests, correct?
Yes.
Now, I want to talk a little bit about your testimony, and I'd like to ask you what you have done to prepare for your testimony in this rehearing matter. Now, as I recall, and correct me if I'm wrong, Mr. Schellinger testified in the rate case in chief. Is that correct?
Yes, he did.
And then I think Mr. Payne testified in the rate case in chief.
Yes.
But you did not.
I did not.
And so as a part of your testimony here, have you had a chance to consult with Mr. Schellinger?
I have.
And have you had a chance to consult with Mr. Payne?
Yes.
And I suppose you've consulted with Mr. Sullivan, correct?
Yes.
And Mr. Jashinsky, correct? Yes. Mr. Morgan, and your attorneys, correct?
Yes.
All right. Now, you've also consulted with parties not within the ORS to prepare for this hearing today, haven't you?
Such as the company?
Such as the Riverkeeper.
Yes.
All right. And so you had communications with the Riverkeeper as a part of your hearing preparation for this afternoon.
We did, as a part of the SIR rebuttal preparation.
And you assisted in the preparation of Mr. Strangler's SIR rebuttal, did you not?
I talked with him on the telephone as part of a group, and then I reviewed his testimony. Yes.
All right. And did you consult with any representatives of the town of Lexington to prepare for today's hearing?
No, we did not.
Has the ORS made any inquiries of the town of Lexington about matters pertaining to the condemnation?
We talked with the town of Lexington at a meeting in 2015, but not in preparation for this rehearing.
All right. And did you talk with anyone else outside your agency to prepare for this hearing today?
Not that I recall.
All right. Now, let's try to establish what we agree on. And let me draw your attention to the EQ liner matter.
Yes.
As I understand your direct testimony in this hearing, you agreed on behalf of the ORS to accept $989,590 of the EQ costs into rates. Is that correct?
Of the $1 million that was in plant and service.
Of the $1,081,375, correct?
That is correct.
And then, subsequently, in your SIR rebuttal testimony, the ORS agreed further to accept an adjustment of $91,785 of the remaining amount from the $1,081,000, correct?
Subject to check on the math.
And if you and sure, look at page 13 of
The only adjustment that we offer remaining on the EQ basin project is to remove $2,200 roughly.
something for grass and something for late fees.
Correct. Correct.
Now, I want to talk a little bit about rate design. Would you please consider for me this? In your petition for rehearing, you argued that the Commission erred in adopting a schedule of rates which was not proposed by the applicant until after the conclusion of the hearing. Do you recall that?
Yes.
And and your petition stated that the Commission erred in adopting a rate schedule which was not supported by the evidence in the record of this case, and which the parties and customers of the system had no opportunity to review or comment on prior to the order. Do you recall that?
That's correct.
All right. Now, as a part of the ORS audit, y'all asked the company about certain calculations that it made in reaching the rates requested in the application, correct?
We did.
And Mr. Hunter responded to those data requests, did he not?
He did.
And as a result of your audit, and as a result of Mr. Hunter's responses to your audit, the ORS concluded that there were about $400,000 in property taxes that the company had assigned or allocated completely to Water Service Territory 1 that should be allocated to the sewer service territory, correct?
That is correct. That was a component of the original hearing.
And these audit adjustments, I mean, it's what the audit provides for, right? It examines the books and the records of the company, and if the ORS thinks that the company has put an expense in the wrong column or in the wrong project or assigned to the wrong service territory, the ORS will object and make recommendations to change those allocations, correct?
Correct. We'll recommend an adjustment through our testimony.
Now, in your direct testimony, your stated concern seemed to be that as a result of the commission order, certain rates for certain customers went down. Is that a fair
That's correct.
characterization? And you could not understand how that operated because you didn't think that Mr. Hunter had provided an adequate explanation for the rate design, correct?
No, I don't think that's an accurate characterization of what our concerns were. Our concerns were that the rates that the company proposed in its proposed order and then adopted by the commission had a reduction in the water, for Water Service Territory 1, water customers in Service Territory 1, that was, the reason for that reduction was not apparent in the commission's order. So we voiced an objection through a petition for rehearing to have that issue examined in the event that somehow the revenue allocation was misallocated or a classification of customer was disadvantaged.
Thank you. And didn't you testify on direct that, quote, CWS witness Hunter does not provide an explanation of how the revenue requirement allocation utilized by CWS in its proposed order and by the Commission in order number 2018345A resulted in a reduction in the BFC for all water supply and distribution customers and a reduction in the commodity rates for all water supply customers in Service Territory 1. Do you recall testifying to that?
That's correct.
All right.
I based that testimony on CWS witness Hunter's description in his direct rehearing testimony, where he details the methodology that he utilized. And in each case, as he's detailing the methodology, he indicates that he applied an increase. So it wasn't clear in his direct rehearing testimony exactly how that methodology looked. Now, granted, witness Hunter did provide, in response to ORS request, information request number 2, which came in anticipation or right before the rehearing, some schedules that allowed for a closer review of how the cost of service was utilized in the rate design.
And didn't you argue in your petition for rehearing, quote, it is incumbent upon the PSC to approve rates which are just and reasonable, not only producing revenues and an operating margin within a reasonable range, but which also, and in your, and this is emphasized in your petition, distribute fairly the revenue requirements considering the price at which the company's service is rendered and the quality of that service. Do you recall arguing that in your petition for rehearing?
It's contained in our petition, yes.
And you understand, do you not, that Mr. Hunter's explanation for his rate design and this commission's rate design is that he accepted an adjustment made by the ORS during the audit in the case in chief and fairly applied it to the sewer and water customers in Water Service Territory 1. You understand that's his testimony?
Through his rebuttal testimony, yes, sir.
But you're not surprised, are you, Ms. Hipp, that the ORS made a $400,000 adjustment in property taxes between the Water Service Territory 1 and the sewer?
No.
All right. I mean, y'all didn't lose a $400,000 adjustment, correct?
No, we did not. I mean, it's definitely apparent through CWS witness Hunter's rebuttal testimony exactly what adjustments the company applied to yield the rate that we saw in the proposed order.
Well, do you think if we were to ask Mr. Schellinger or Mr. Payne now, if the process would permit it, whether they were aware of the $400,000 adjustment, do you think they would tell us they were well aware of the $400,000 adjustment?
They would.
All right. And so, as I understand the way the ORS calculated the rates, ORS replicated the revenue allocation based on the rates proposed in the CWS allocation. ORS applied as close as practicable the allocation percentage to the proposed revenue requirement to determine the amount of revenue requirement for each customer class. Is that how y'all allocated it?
Yes. Yes.
And so what the ORS failed to do is to properly allocate the adjustments that it made to the company's application in designing its rates. That's true, isn't it?
No, that's not. That's not a true statement. ORS did use the cost of service as approved by the Commission as a basis for its revenue allocation. What ORS did do, instead of applying a 10.5 ROE as the company did, ORS utilized the same increased percentages that the company used in its original application. It just carried that methodology all the way through, utilizing that $400,000 adjustment that you speak of.
So, go ahead, please.
I think what we have here fundamentally with the rate issue is just a failure to communicate. So we appreciate the company's further detail within its testimony to understand more fully how they developed the rates that resulted in what we thought was maybe a concerning disadvantage to other customers. Now that that has been fully explored and hopefully will be included in any subsequent Commission order, we're satisfied with that, and there is no dispute on the rate design.
So it's the ORS testimony that the adjustment, it had the $400,000 adjustment.
Correct.
And it applied it to its rates. But somehow Mr. Hunter's rates were more accurate.
I wouldn't say they're more accurate. I think we went about it in two different methodologies. There isn't one specific methodology utilized. We came at the problem two different ways, yielding two different results. We were unable to determine at the time that the company filed its proposed order and the Commission subsequently ruled what methodology was used. As of today, we have resolved that issue and we're satisfied with what's contained in the Commission's order related to how the revenue was allocated.
So you agree with me when I say that the Commission's order distributed fairly the revenue requirements in this case?
Based on the details that have been provided through testimony, we would agree.
And you would agree with me that the ORS erred in arguing that the Commission erred in adopting a schedule of rates which was not proposed by the applicant?
No, I wouldn't agree with you.
Now, with respect to sludge hauling, as near as I can tell, Mr. Sullivan's testimony in this docket is very similar to Mr. Payne's testimony in this docket. Would you agree with that characterization, Ms. Hipp?
Yes, he sponsors the same adjustment.
And the ORS is relying strictly on test year data to reach the conclusion in Mr. Sullivan's testimony, is it not?
No.
Please explain what additional data you're relying on.
If you take a look at Mr. Sullivan's table that is contained in his direct rehearing testimony, Mr. Sullivan and Mr. Payne adopts Mr. Payne's adjustment, uses a 3-year average. So we took a look at the sledge hauling expenses for the 12 months ending August 31st, 2015, August 31st, 2016, and August 31st, 2017. So we did not rely specifically on test year data to develop the 3-year average.
Well, thank you for that clarification. You relied on test year data to determine that there was some extraordinary sludge hauling expense, correct?
Yes, that's witness Sullivan's testimony about what the audit department did.
And so Mr. Sullivan's testimony offers no new ground in that regard for a reversal of the commission, correct?
Mr. Sullivan's testimony specifically encourages the commission to look at ORS's adjustment and the practice of normalization.
Again, correct?
Correct.
Now, you say you're relying on strictly the test year sludge amount to determine its extraordinary nature, but really you point to the water company's efforts to interconnect the Friarsgate system to the City of Columbia as a justification for your 3-year average of the sludge cost, correct?
Yeah, I think it's important to look at the test year. The company controls the test year that is selected in its rate case. So it's important to take a look at the test year, and as witness Sullivan detailed, look for abnormalities. The audit department's developed a threshold to do that. What we find interesting is that our normalizing adjustment, which does incorporate those higher expenses from 2017, is actually supported to be a reasonable balance as the expenditures for sludge hauling have been reducing over time, as the CWS witnesses on demonstrate.
But you were here when Mr. Carton testified that if the sludge hauling figures go away, there will be additional costs that the company will have to pay in lieu of the sludge hauling costs.
I heard him mention that there'll be increased cost.
And you understand that to be the case, don't you, Ms. Hipp?
Not based on, based on the information that he has offered. ORS has not verified any additional expenditures related to that contract, so I can't offer an opinion on that issue.
Well, I'm not asking for an opinion, Ms. Hipp. What I am asking is, won't the bulk sewer costs go up as a result of an interconnection?
There will be bulk sewer costs. Whether or not that equates to an increase or decrease in expenses is unknown at this time.
And the bulk service will be an increase, correct?
The bulk service will be a new charge.
A new charge.
So that very well could be offset by reducing charges in labor or other things such as sludge hauling. I simply don't know.
And you're aware that the company has hired Clearwater to manage the Friarsgate system?
Correct.
You know that's a cost that was not in the test year cost, correct?
Company did not bring that cost forward for recovery in the test year.
And so the status of that interconnection agreement is that it must be approved by the commission, correct?
Correct.
And it first must be reviewed by the ORS, correct?
Yes.
And the commission could determine, in its wisdom, not to approve the interconnection agreement. Isn't that correct?
We certainly can. Our review as a party of record will occur, regardless. It doesn't have to happen first before the commission makes its determination.
So clearly the interconnection agreement at this point is a contingency. You would agree with that, wouldn't you?
It has been filed and it has not been approved.
Now, you testified in your direct that legal expenses related to disputes such as workers' compensation claims or right-of-way procurement may be a, quote, cost of doing business, unquote, and included in customer rates. Do you recall testifying to that?
Yes.
All right.
In fact, in the rate case itself, we did include expenses, legal expenses related to property easements and those sorts of things, not workers' comp, but property easements and some of those items.
Well, in fact, the costs that would be included as a cost of business is broader than your two examples, isn't it?
Correct.
The company may have legal expenses for negotiating contracts.
They certainly may incur all sorts of legal expenses outside of those that flow through customer rates.
Such as contracts, correct?
Correct.
Such as merger costs, correct?
Depends on how the merger is structured.
Did you include merger costs in this?
I
In your
don't
schedules in this
recall
matter?
that we saw merger costs. Let me just take a look at what we had seen in terms of legal costs. The legal costs that we included just in general related to property easements, DHEC permitting, the West Columbia bulk water contract negotiations. We allowed $88,765 of the original $145,495 that the company had requested.
Good. That's helpful. And we can agree, can we not, that utilities such as Carolina Water may find themselves in litigation from time to time, can't we?
Yes.
We can agree that on occasion Carolina Water may have to bring a lawsuit, correct?
I mean, it is possible, yes.
And we can agree that from time to time they may find themselves as a defendant in a lawsuit, correct? And I do not understand your testimony to be that all litigation costs are excludable from rates.
You're correct. That we think that litigation costs and legal expenses should be looked at on a case-by-case basis. And we have done that in this case.
And tell me if this fairly summarizes the ORS position on the Riverkeeper litigation costs. The ratepayers received no economic benefit from Judge Seymour's order, which held that CWS violated its environmental permit and imposed serious and costly penalties. Is that a fair statement? Does that
Correct.
fairly describe your objection?
It does. It does.
All right. Now, you've been here for all day, correct? And you heard the testimony of Mr. Gilroy.
Yes.
You heard the testimony of Mr. Babcock. And you heard the testimony of your witness, Mr. Stangler, correct?
Correct.
And isn't it true, Ms. Hipp, that when this lawsuit was filed by the Riverkeeper, the I-20 customers were threatened with the loss of service?
It's difficult. Our agency, the ORS, was not a participant in any of these litigation efforts, either on the company's behalf or the company defending itself. So it's difficult for me to talk about what the intention is of someone bringing suit against the company or the company in reverse. I can't answer that question.
You heard Mr. Babcock's testimony, did you not?
I heard him testify to the reasonableness of the expense.
You heard Mr. Babcock testify that the company was faced with three options: interconnect with the city of Lexington, sell to the city of Lexington, or shut down. You heard his testimony.
That was his testimony, yes.
And you heard your witness's testimony, Mr. Stangler, who testified a moment ago that his lawyer told the federal judge, Your Honor, shut down of a facility that is not in compliance with the Clean Water Act is relief that we sought. You heard Mr. Stangler testify to that.
I heard him read that excerpt.
Right, and you understand the excerpt was from a transcript. You're familiar with transcripts, are you not?
Correct.
And you understand that you know Mr. Hallman.
Yes.
He appears before the commission, correct?
Yes. Oh, I'm sorry. Yes.
Appears before the commission, correct. And he was representing Mr. Stangler, correct?
In that lawsuit.
And you heard
based
Mr.
on the
Stangler.
transcript.
And you heard Mr. Stangler testify that Mr. Hallman had Mr. Stangler's authority to inform the court that a shutdown of the I-20 system was relief that they sought. You heard that.
It's written in the transcript.
And tell me how the shutdown of the I-20 system would benefit the I-20 sewer customers?
I think the characterization of the shutdown of the I-20 system as being a possible outcome or a logical outcome is inaccurate. I mean, it certainly is a possibility, but you're looking at other state agencies that would need to approve of that, potentially, that outcome. It certainly is not the outcome that Judge Seymour anticipated in her opinion and order, which is what ORS relied upon as it's making its recommendation to the commission to disallow those expenses. The judge found that the company had violated its permit. There's no economic benefit to customers who are currently paying service charges for the company to operate in compliance with that permit, for then the company to be found in federal court to have violated the permit on repeated occasions, to be fined, and then to be told to find a rational way to interconnect or stop the discharge. Judge Seymour didn't order that, and that's not what ORS's basis for making this recommendation.
Thank you for that. Please tell me what benefits the I-20 customers would receive from a shutdown of the I-20 system.
I don't know. I mean, one could look at it as, a migration to an alternative. So the shutdown doesn't mean termination of service to the customers. Today I can flush my toilet, run my dishwasher, run my washing machine. Tomorrow I can't. A shutdown of the service means elimination of that charge, whether it be through sale, condemnation, some other alternative. Mr. Stangler identified other alternatives. The problem is CWS's problem. In its permit, it voluntarily agreed to this condition and then did not adhere to that.
So it's fair to say that if the I-20 customers were shut off from their sewer system, they would not benefit from having no sewer service. Isn't that true, Ms. Hipp?
If service were terminated to a customer or customers, as a result, you're correct, they would not have service.
And they would not benefit. Thank you. Now, you've got, you raised several questions about some of these fees, and I think, if I understand your testimony, you are satisfied that the Winston and Strawn invoices are applicable to the Riverkeeper suit. Is that correct?
Through company rebuttal testimony, company witness Carton provided additional information in his rebuttal. It did not come in with the information request responses to ORS, nor did it come in through direct testimony. Through rebuttal, he indicates that through an affidavit that work was done in support of the Congaree Riverkeeper. The allocation, the company did not make an allocation of those charges in the proper manner such that we could discern it. We agree that it should be allocated to the Congaree Riverkeeper, and subsequently it should not be allowed for recovery rate.
Good, thank you. And you had questions initially about the Baker, Donaldson, Bierman, Caldwell, and Berkowitz invoices. Where did you finally allocate those invoices to?
There was no definitive allocation. ORS removed them.
And you were...
And it was, just to make sure that I get this clear on the record, it was the expenses and advances that were contained in those invoices that were unallocated by the company. The company had an opportunity to allocate as the commission requested and disaggregate those expenses, and it didn't do that.
What was Baker Donaldson representing the company for?
I couldn't tell you. I mean, we'd have to go ahead and look at the invoices.
But you have the invoices?
Yes.
All right. And I think you concluded that the Berkeley Economic Consulting expenses were properly allocated to the Riverkeeper case, correct?
Right. After the rebuttal testimony, the company revealed that the allocation belongs to the Congaree Riverkeeper. ORS agrees with the allocation, and it requests that the commission remove those expenses.
And you are satisfied that the consulting services of Hartman Consultants and Winthrop Real Estate are allocable to the condemnation matter, correct?
That is correct.
And then you had concerns about the redacted invoices from Willoughby and Hafer, correct?
Yes, we did.
And ORS has accepted redacted invoices from attorneys in the past.
We have.
And the reason for redacted attorney's fees invoices are that those invoices are not confidential by law, or were not in this case, correct?
The invoices provided to ORS under the new statute that ORS abides by were confidential.
When they were provided in this case, they were not.
When they were provided in the original case to ORS and then returned to the company, no.
And the ORS has concerns in these cases that if those records are public, that members of the public could see them and ascertain what, not just what the costs are, but what the legal tactics and strategies are, correct?
ORS doesn't have concerns that the public can see it. The company has expressed concern about the public seeing it.
Well, you can understand why the company would have concerns, could you not? For instance, in this case, you have worked with the Riverkeeper, in this case, to try to block recovery of these legal fees, have you not?
No, we have not.
The Riverkeeper was not a witness on behalf of the Office of Regulatory Staff?
We did not work, the characterization that ORS worked with the Riverkeeper to block the recovery is inaccurate. Riverkeeper is here simply to respond to rebuttal that the company put in related to characterizing the intention of the Riverkeeper's lawsuit. ORS was not a party in the federal lawsuit. We cannot speak to that. We wanted to make sure that the commission had a party to speak to the intention, and who better than the Riverkeeper to do it?
You can understand why the company would have some concern that you would share its legal strategies and tactics with the Riverkeeper, can you not?
I don't understand the question. ORS did not share the legal expenses with the Riverkeeper. ORS, in fact, kept the confidential documents in a manner such that only ORS employees would be able to look at it. So the Riverkeeper didn't review legal expenses related to this. They were here simply to testify as to what happened in the federal lawsuit.
Now, in your petition for reconsideration, you argue, quote, there's additionally no precedent for or evidence in the record of this case to explain why the company was permitted to expense legal fees over a period of 66 years. Do you recall that?
I believe that's in our petition for hearing and reconsideration.
All right, and you recall a few minutes ago I asked you if you had consulted with Mr. Schellinger about your testimony today. Do you not?
Correct.
And I think you recall my asking you a few minutes ago if it was not important for the ORS to look back to previous rate cases to establish certain baseline kinds of data, correct? Now, you've been with the ORS since almost the beginning, I think, have you not?
Since the beginning.
And you've been in water and wastewater all that time, correct?
Correct.
And you may have heard me say to you and to others that oftentimes you know more about my clients than I do. Do you recall ever hearing me say that?
I think I've heard you say that.
Yeah. So you're very familiar with these cases and the history of these Carolina Water Service rate cases. That's fair to say, correct?
Yes.
And you recall Mr. Schellinger testifying in the 2015 199WS docket that the ORS proposed to remove certain deferred charges. These charges consisted of expenses for I-20 litigation efforts and deferred expenses for tank inspections. Do you recall his testifying to that?
Vaguely.
But you don't dispute it?
I don't. Subject to check. I don't know if it was Mr. Schellinger or who that was, but it sounds familiar.
And Ms. Gearhart, is she still with y'all?
He's not.
All right, but she was the audit witness in that case. Do you recall that?
Correct.
And Ms. Gearhart, in docket number 2015-199 WS, demonstrated this adjustment that Mr. Schellinger proposed in his testimony in that case. Do you recall that?
I'm subject to check, yes. I understand that this was a settlement agreement where ORS and the company agreed in the context of a settlement agreement to include some limited expenses related to the I-20 litigation and amortize those over a period of time in the context of the 2015-199 WS case.
Thank you. And you'll recall that in that case, Carolina Water actually sought in its application to recover about $121,000, $121,516 to be exact, in rates, earning an ROE. Do you recall that?
Subject to check. The dollar amount sounds familiar, and the rate-based treatment of those expenditures was an issue, yes.
And the ORS declined to accept that allocation, but proposed instead recovery of $121,516 amortized over 66.7 years with no rate-based treatment, correct?
In the context of the settlement, yes.
Well, help me understand what you mean by that, because as I recall you're testifying, the ORS sends out a couple of hundred audit requests, correct?
Correct.
And the ORS makes certain adjustments, correct?
Correct.
And the ORS is very good at the end of its audit period. It will have an exit conference or an exit interview. Is that correct?
We do.
And the ORS will sit down and will tell the company all the adjustments that it proposes, correct?
Yes, we do.
And in addition, the ORS is very good about providing the company with their work papers demonstrating what adjustments they're making. Y'all do that, don't you?
Upon request of the company, we definitely will provide our work.
And you recall that in the 2015 case that the company asked for this adjustment information, and that Mr. Schellinger provided them with the ORS adjustments and the work papers demonstrating those adjustments. You recall that, don't you?
I believe we did.
All right. And of course, that's before a settlement. That's during the exit interview. That's before the case has been settled. Isn't that correct?
I believe so.
All right. So this is an adjustment that y'all made irrespective of a settlement, correct?
Correct.
So it would be reasonable for the company in its 2017 rate case application to seek the same treatment of its I-20 litigation costs as recommended by Mr. Schellinger in the 2015 case.
It certainly would be reasonable for it to seek those costs. It doesn't mean that it's reasonable to recover them in that manner. And ORS offered, obviously in this case, offered a differing adjustment.
And so when you write in your petition for rehearing that there's no precedent for this sort of accounting treatment, that's not really true, is it?
I don't know that I necessarily disagree with our wording. This is a unique situation. Again, looking at legal expenses on a case-by-case basis, this is a large dollar sum related to an effort or a legal action where the company violated its permit. The company requested to recover that over the life of a plant asset, a comparable time such as the life of a plant asset. And we think it was an attempt to camouflage the volume of expenses such that customers would not notice it in rates. Because what it really boils down to at the end of the day is in rates right now for the first year is $14,000. Well, that's insignificant or could be insignificant. On the aggregate, that's a very large amount that customers are paying for a legal action where they received no benefit and the company was found to have violated its permit. It's not reasonable to expect that because the company incurred legal expenses that it should be allowed to recover it through rates to customers for that period of time.
So it's your testimony that the company was acted unreasonably to rely on the ORS recommendation in the previous case.
I think, every rate case is a different scenario. In the case where we have a settlement agreement, there's language, it was read earlier in the record, that it's not precedential setting. The company is free to offer its adjustments. So it can offer its adjustments. That doesn't mean that ORS is going to agree to it or that the commission is going to agree to it.
And so when the ORS recommended an accounting adjustment in 2015 to recover $121,516 in I-20 litigation costs over 66.7 years without rate treatment, was it obviously attempting to hide those costs?
I don't think so. I think at the time, with the information that we had, that was a good adjustment. The dollar value was very low. The legal expenses were, not significant at that time. And that adjustment, when offered, could have been rejected very well by the commission, but in a comprehensive settlement, the company agreed to that and ORS agreed. Settlements are a give and take.
And so let's go back and let's look at the interconnection between Friarsgate and Columbia, please. As we discussed, the status is that Carolina Water has negotiated an interconnection agreement with the City of Columbia, correct?
That's correct.
And the company has filed a request with this commission to approve the agreement, correct?
That's correct.
The ORS has an opportunity to investigate the benefits of that agreement, correct?
Yes.
And ultimately, it's up to the commission to decide whether to approve it or not.
Correct.
And if, let's assume that the commission, in its wisdom, decides to disapprove the agreement. And for the purposes of my question, let's assume that a part of the permit, CWS's permit, is that when the regional provider is available, it must connect. And let's assume that because the commission disapproves the agreement, the company is in violation of its permit. And last, let's assume that some enterprising young man sues the company because they have violated their permit. May Carolina Water Service defend that case, Ms. Hipp?
I think you're asking me to do a lot of speculation on this issue. I mean, these are hypothetical situations that you're asking me to render an opinion on when all the facts aren't known. I'm not looking at those legal expenses. I don't know the context aside from the assumptions. I'm not comfortable offering you an opinion on that issue.
But you are comfortable giving me an opinion on the company's reaction to being sued by the Riverkeeper on the I-20 system, are you not?
Most definitely. And I'm supported by an order from the federal judge related to, what was found, what the company was found to be in violation of. That's finality. And these customers should not pay for those rates related to that. It's just not reasonable.
And is your testimony that the company should have simply surrendered to the Riverkeeper when he filed suit?
My testimony is that the company can defend itself in any lawsuit that its management deems necessary. My testimony indicates that ratepayers should not be liable for those charges. The company management wants to defend itself in court on differing lawsuits. It's this commission that determines what goes into rate. And our position, ORS's position, is that these costs should not be passed along to rate. If the company wants to incur them, then the shareholder.
So it's your position that the ORS position is that when faced with a lawsuit which may have resulted in the loss of service for at least 2,000 of its customers, it had no business defending the case and protecting the rights of the customers.
That is not my testimony.
No further questions, Mr. Chairman.
Thank you. Commissioners. Commissioner Whitfield.
Thank you, Mr. Chairman. Just a couple of questions for the panel. Been here a long time today, so I'll start with you, Mr. Sullivan. Mr. Sullivan, in Michael Carton's rehearing direct testimony on pages 5 and 6, I'll give you a second to get there. You may not need it for what I'm going to ask you, but you want to go ahead and get there. There.
I believe so.
Okay, he states that the company hired Clearwater Solutions to mitigate Carolina Water Services sludge hauling expenses. Did ORS take the Clearwater contract expenses into consideration when you reviewed your rehearing adjustments?
No, we did not. And I just would like to point out, because I heard contract services earlier, our cutoff date, as was mentioned by Mr. Carton, our company witness Carton, previously he indicated our cutoff date was February 12th, 2018, which is correct. We also toured the Friars Gate facility on February 22nd of 2018. At that time, there were no mention of contract services. There were still CWS employees running that facility. The contract services was not mentioned except subsequent to February 22nd, when our testimony was due March 12th.
Okay. I think I'd heard Ms. Hipp tell Mr. Elliott just now that the company didn't bring those costs forward, I think she said, but I wasn't sure what ORS ended up doing. And I know there's been a lot of discussion about the recommendations Clearwater had, such as the sludge press and that sort of thing. So what you're saying is, at that point, February 22nd, you didn't have the company didn't bring these forward, as she said. So you didn't take that into consideration when you reviewed the rehearing adjustments.
Correct. As part of the rehearing, we just substantiate our original position on normalizing sludge hauling costs. We have looked and verified all the invoices that were provided for the updated sludge hauling costs. They are supported. We've never had an issue with the sludge hauling costs being supported by invoices. But in regards to bringing up other areas where costs have increased, et cetera, those weren't items brought to the attention of ORS during its initial review.
According to his testimony, going forward, it might be going down because of the recommendations they were offered.
On the sludge hauling,
right?
If they potentially, if the interconnection goes through, then the sludge hauling could potentially be zero. Correct.
But you'll have the bulk costs that have been mentioned.
Correct.
Which, as she said, would be a new charge going forward.
Correct. And I'd elaborate on what she said earlier. The contract services, obviously, if you bring a contract employee in or a contract company in, then what happened to the employees that were at the facility? So you're going to have, I think Mr. Carton touched on this earlier, you're going to have some costs go up and you're going to have some costs go down. And until you can perform a thorough and extensive audit on that, you don't know the exact effects on whether it's going to be an increase or a decrease, or how much of an increase or how much of a decrease, et cetera.
Right. Thank you. One more question for the panel, and Ms. Hipp, if you want to answer it, is certainly fine, either one of you. And I hesitate to do it, it's a little speculative in nature, but the fine that's been discussed, and I think Mr. Babcock made a lot of discussed a lot about the getting the judge to withdraw the $1.5 million penalty. But going forward, there's a lot of back and forth after Mr. Nelson crossed him that could come back, and of course we don't know how much. Does ORS have an opinion as to what they think might happen with that $1.5 million penalty, and if so, could you share it?
And again, Commissioner, just to make sure you understand, ORS is not a party to that.
Correct.
So we're
right.
not a participant. We are watching closely
Right.
to see what happens in that case.
I realize you're not a party,
Right.
but do you have
Our opinion is that whatever the penalty is, whether it's $1 or 1.5 million or 2 million, the customer should not pay for that. And so whatever it is at the end of the day, through the proceeding that they have or discovery or however that's decided, we'll make sure that the customer does not pay that penalty. Likewise, we'll make sure that the customer doesn't pay the legal expenses related to negotiating what that penalty should or shouldn't be.
Thank you, Ms. Hipp. That's all I have, Mr. Chairman.
Thank you. Commissioner Elam.
Ms. Hipp, given that you'll make sure, or at least obviously you'll recommend that customers not pay that fine, is a fine like that some incentive to operate the systems, in compliance with their permits?
One would think so. The other incentive would be that the company cannot receive rate recovery for these types of legal expenses. That's a significant deterrent.
Yeah, I don't believe ORS has ever recommended that customers pay for fines.
We have not.
Mr. Sullivan, normalization. When you use the concept of normalization, do you do it for single expenses or do you do it for the package of costs as a whole? You don't do it for the package of costs as a total, do you?
No, I mean, you take everything into consideration during the course of a review of a rate application.
Right.
And that's why I brought up in my testimony. I mean, we realize other costs were going up, as such as salaries and purchase water expenses and purchase sewer expenses. So I mean, we take it all at a whole, but specifically in this case, it was the increase in sludge hauling expenses during the test year that stood out, and we take the position that they should be normalized.
Okay, thank you.
Commissioner Hamilton.
Thank you, Mr. Chairman. And one question, Ms. Hipp. We've talked a lot today about litigation, but could you tell me or help me, other than the CWS versus the EPA in the town of Lexington, have any orders been issued on other litigation?
No, the two sets of litigation where orders have been issued, you've properly characterized. One is the Riverkeeper lawsuit, and the other is in the CWS versus US EPA in the town of Lexington. Those have orders in them. The other case is the town of Lexington condemnation, the administrative law court appeals of the DHEC orders. There may be procedural orders in those, but a final order has not been issued.
Thank you, ma'am, very much. Hope we ended today.
Commissioner Williams.
Yes, Mr. Chairman, thank you. A couple of questions. This is for Ms. Hipp. If a system is constructed according to DHEC's loading requirements, could there be times when the load on that system exceeds capacity and discharges above NPDES limits?
Again, I'm not a DHEC expert on the permit, but no, I think if the permit is designed properly and the load is correct, you won't exceed capacity. Now, there's going to be weather, inadvertent weather issues, hurricanes, the flood, that type of thing that may impact that. I don't know.
If the limits were exceeded, do you think it would be the company's fault?
The company is responsible for maintaining safe and efficient operations within the parameters of its permit. It would be up to DHEC to determine whether or not the company was at fault.
A couple of questions about this litigation. You've been doing this for a long time, right, in terms of working for ORS?
Yes.
So this is not your first rodeo?
No.
I'm trying to understand what the reasonable response for the company would have been when faced with a lawsuit. And where I'm going is, I think your testimony in some way, shape, or form considers it considered it unreasonable for the company to defend itself and then ask for the ratepayer to pay for the cost of that litigation?
No, I don't think that's my testimony. My testimony isn't that it's unreasonable for the company to defend itself. It's that it's unreasonable for the ratepayer in the situation of the Congaree Riverkeeper lawsuit that resulted in the federal order finding that the company had violated its permit. It's unreasonable for the ratepayers to pay for those legal expenses. That's what's unreasonable. It's a policy issue. It's not the standard of the expense or what the company should or should not have done. The fact of the matter is that the ratepayer should not pay for that. It is just because a company incurs an expense, it doesn't automatically mean that the ratepayer pays for it. There's an incentive inherent in regulation for regulated utilities.
What if the outcome would have been different?
It's a great question. We've batted that one around in the office as well. You know, what if they had prevailed? Again, it's a case-by-case basis. We would look at the outcome and make a recommendation to this commission. You know, we may go granular on those expenses. We didn't challenge the reasonableness of the dollar value, the hours spent. There may be a closer look.
Okay. So you're saying that it's hard. It's only two outcomes, generally speaking, win or lose. And so your testimony is you don't know whether or not it would have been reasonable or unreasonable if they would have won?
I don't, because we would look at the order, such as we have done here, and see what the components of the order were, whether or not the company was found to have violated its permit but prevailed on some other issue. You know, what we're hinging on here is that the company was found to have violated its permit.
Thank you.
You're welcome.
Commissioners, any other questions? Ms. Hipp, just one and a half. Page 14 of your pre-file direct rehearing testimony states says CWS versus EPA in town of Lexington case had no quantifiable benefit to the ratepayers. Define quantifiable benefit.
One that you can touch and feel, one that impacts the ratepayer. The company provided no support except to say, as we have heard today, termination would be a terrible outcome. So obviously the benefit to that is to remain and have service. That's not a quantifiable benefit in my mind.
Would ORS consider the resulting interconnection with Lexington sewer system to be a quantifiable benefit?
I don't know. We're still looking at the interconnection request that's been brought before the commission. We've got some information requests that we're looking at the responses of, and we'll be looking at the economic benefits potentially for the customers, the cost-benefit analysis that the company may have performed, and we'll make reasonable recommendation to the commission.
Thank you. Commissioners, anything else? Any redirect? Heard that before.
Ms. Hipp, we've heard in questioning, we've had references to the I-20 facility and the I-20 system. Is there a difference in the I-20 facility versus the I-20 system?
Not in my mind.
Does the system encompass more than the wastewater treatment facility? And what would the system include?
Well, the system would include all the collection system, piping. One could interpret that to mean the service territory as well, the customers.
Mr. Chairman, may I approach the witness? I'm referring to, I'm not sure which hearing exhibit. It's this transcript that was from the Congaree Riverkeeper case that Mr. Hafer produced. And I'm referring to page 55. And I want to ask Ms. Hipp if she would read lines 11 through 16. Chairman, this is a portion that was referenced earlier, and it was, I believe, when Mr. Hafer said that Mr. Hallman was, this was Mr. Hallman speaking, And it's lines 11 through 16, please.
Your Honor, shutdown of a facility that is not complying with the Clean Water Act is relief that we sought. It is relief that is appropriately considered and should be considered at the appropriate time. No one wants to create a public health emergency, but we do need to stop the environmental degradation that's happening.
And the term there used is facility, is it not?
Correct.
Not the entire system that would include all the piping to the customers, and that Mr. Scott kept referencing as shutting down the system. Is that correct?
Correct.
Thank you.
Okay, I'm not sure that that entire transcript has been entered, Mr. Butler saying, and Ms. Wheat as well, so would you be willing to enter that? Either one can enter that as an exhibit. Okay. Thank you. Okay. That will be exhibit number 19. And okay. Any recross? Thank you. Okay. We'll excuse this panel, or you may step down. Anything else, Ms. Belser?
Out of these, but no further witness.
Okay. All right, I think we to the point where we need to go through the list of exhibits.
Yes, sir, Mr. Chairman. Exhibit number 1 is the transcript of the original transcript of testimony here on this case in the same docket, and the exhibits 7 through 18. The original hearing was held 4/3 through, and 4/3, 2018. Exhibit 2 is the rehearing rebuttal exhibits of Michael Carton. Exhibit 3, direct exhibits of Robert Hunter in this case. Exhibit 4 is a late file exhibit from Mr. Hunter, which would be a unitary rate, I think, for both territories 1 and 2. And exhibit 4 is a late filed exhibit. It would be the book value and fair market value of the I-20 plant. Okay, well, excuse me, make that exhibit 5 would be the late filed exhibit for the book value and fair market value of the I-20 plant. Exhibit 6, Mr. Laird's rehearing exhibits on direct. Exhibit 7, Mr. Gilroy's rebuttal rehearing exhibits. Exhibit number 8, Mr. Babcock's rehearing appendices. Exhibit 9. Exhibits 9 through 13 are cross-examination exhibits of Mr. Stangler, presented by Mr. Hafer. Exhibit 9 is a Lexington Coventry Woods document. Exhibit 10, CWS I-20 Echo document. Exhibit 11 is a November 17, 1994 surface discharge permit, CWS. Exhibit 12 is a 3/15/2004 DHEC order. Exhibit 13 is the surface discharge permit, Coventry Woods. Exhibit 14, Mr. Sullivan's rehearing audit exhibits, direct. Exhibit 15, Mr. Sullivan's surrebuttal exhibits. Exhibit 16 would be Ms. Hipp's public versions of her exhibits 1 through 8 direct, and then exhibit 17 would be the confidential portions of exhibits, and I believe it's a Ms. Hipp's exhibits 2, 3, 4, and 5. Exhibit 18 is Ms. Hipp's surrebuttal exhibits, and then exhibit 19 is the transcript that we just made reference to. Thank you.
Okay, anything else to come before the commission for this hearing? I know we got proposed order date of October the 16th that everybody's agreed to. Is that correct? Oh, they haven't agreed? Okay. I was just throwing out that subliminal suggestion. Thank you, thank you. Everybody good with October 16th? Okay. All right. Nothing else to come before the commission for this, and we are adjourned. Thank you.